morning, everyone. We would like to welcome you to another edition of The Pulse here on Cayman Mall Road. Today we're going to be speaking with Dr. Mohanty, who's going to introduce himself here in a minute for those of you who may not be aware of who he is. But we're going to be discussing some proposed legislative changes to the Health Practice Amendment and Validation Bill 2020. This bill is coming before the Legislative Assembly. I understand, pretty much now as we speak, there's quite a bit of discussion that's occurring on this piece. And there are some concerns in the medical profession regarding some of the proposed changes and what the real implications of those changes are for the average person in the Cayman Islands. Good morning, I'm Dr. Mohanty, and thank you so much for joining us.
Thank you for allowing me to participate. I am Dr. Mohanty. I have been on the island since 1991. I came here from the United Kingdom and I worked for almost 11 years in the civil service and did my stint as a civil servant, both here in Grand Cayman and at Cayman Brac as the medical officer in charge of Faith Hospital. In the year 2000, I came and left civil service to become a private practitioner, and since then I've been in private practice as a surgeon and urologist in Grand Cayman.
Okay, well, thank you so much for that background information. I think that's incredibly helpful for persons who may not know a little bit about who you are. I'm sure the name sounds familiar to them, but now they know all of the credentials and experience that you're, not all of it, but a lot of the credentials and experience that you're coming to this discussion with. So let's go ahead and kick it off, right? So can you tell us what really are your major concerns? Now, we know that you have penned several letters of correspondence, one to the Premier of the Cayman Islands, the Honorable Alden McLaughlin, and then another one to the Governor of the Cayman Islands, Mr. Martin Roper, where essentially you have raised some concerns about this bill, which is proposing some changes to the health practice law here in the Cayman Islands. So let's go ahead and break it down as much as we can for the benefit of our viewers who a lot of times don't understand the technicalities of these bills, and certainly they often don't understand the full implications of it until it's a little bit too late. So give us an overview, and then we're going to go into some further details about the specific areas of concern and why we should all be worried about the proposed amendments.
Right. When medical tourism came into focus in the Cayman Islands, the previous governments under the stewardship of Mr. Bush and then followed on by Mr. Alden McLaughlin, they gave their blessings to medical tourism, and I must say it was done in good faith because everybody believed in the promises that were given to us by Health City.
Right.
One, that they would bring in medical tourism in the thousands, they would create jobs in thousands, and millions of dollars in revenue would be gained to the economic benefit of the Cayman Islands.
Okay, so let's just pause it right there. When did Health City come into operation? How long has that been now?
I believe 2013, 2014.
Right. So the basic business case that they submitted to the Cayman Islands, and obviously, as a result of that, they got a lot of concessions and special consideration, was essentially that their main focus would be providing heart-related surgeries.
Yes, the Memorandum of Understanding, short form MOU, which was signed by our government and Health City, clearly stated it was medical tourism and tertiary care. Tertiary care, by definition, stands for services not rendered locally.
Okay, so services not rendered locally, and it seems initially their focus wasn't a lot of cardiac related specialties.
Cardiopulmonary, lung related, and a little bit of orthopedics.
Right. And then medical tourism, which the idea there is obviously you're bringing in patients from all over the world
who fly in for that purpose.
Right. Okay. And in your opinion, you said it was done in good faith. Obviously they got a lot of customs and building concessions, stamp duty concessions, even work permit concessions. Yeah. One of the things which is critical to understand is even in terms of how their physicians are licensed, they got a concession in that regard as well.
Yeah,
Can you break that down a little bit for
that
us?
was the first bone of contention when the first idea came about to allow these facilities to function in the Cayman Islands. And there was concern between all the councils of the Cayman Islands, the councils being the bodies which advise the government. All of them advised the government against allowing them to have a system whereby these physicians would not be capable of being registered locally, but they would be functioning. Advice was given against that, safeguards were attempted to be put in, but these all fell on deaf ears. These advices all went into file 13, table 13 something. It was never adhered to.
Okay, so when you say that they can't be registered in the Cayman Islands, but they can practice, explain to, again, our viewers who may not understand what that means. What exactly are you trying to say? What's the difference between 99, I understand it's pretty much all the physicians, but let's say 99% of the physicians at Health City versus all of the other physicians who work outside of that institution?
Right, okay. The way health practice performs through the function of the councils, that is the Medical and Dental Council of the Cayman Islands. This is the body which regulates licensure of practicing physicians. They look at the knowledge, skills, and experience of the client, which is validated by their documentation of the credentials, the experience, and then they provide the licensure. Up till medical tourism was promoted, there were only two registers on this island, and one was the principal list and one was the provisional list. The principal list consisted of physicians who were doctors or who were specialists, and the provisional list consisted of physicians who were in training, and this list allowed them to continue their training over here. There was no institutional registration before medical tourism existed.
Okay.
Then came the divide. And the divide was, if these doctors are coming from India, and they would be allowed to practice in that facility as doctors with Indian qualifications, but that did not allow them to satisfy the criteria of the health practice law, which did not accept Indian qualifications.
Okay, so the health practice law at the moment, and before this actual change and this division that you're talking about occurred, accepted physicians from what countries and what qualifications? So we're talking about the United Kingdom, Australia.
Yeah, I do have a list of it here, which is available, and basically it was the 7 civilized big Western nations of the world: America, Canada, New Zealand, South Africa, the United Kingdom, Europe, and Jamaica.
Okay, because at some point we felt that those countries, the qualification process that physicians go through was stringent enough that if you were already a physician in that particular jurisdiction, you could easily transfer those skills over into the Cayman Islands and get the required licensing here.
Correct.
To be a physician and to practice.
We were too small a jurisdiction to say that we have our own college or our own accrediting body. So we relied on the licensing experience of these bodies to say that, hey, what is acceptable for their people over there is acceptable to us. And I mean, a case in point is mother country, United Kingdom. What's good for her is automatically good for us, and we accept it.
Right. Okay. So India is not on that list.
Neither. India is not on that list, neither for basic medical qualifications, that is, in order to be considered a doctor. And nor is it recognized for specialist medical qualifications, which is called postgraduate medical qualifications. So there is a difference between a doctor who is a general practitioner, and there is a difference here. We have a specialist who's got postgraduate qualifications, whereby he is now considered to be a specialist delivering specialist medical care. So these physicians that we are talking about in the institution, at the facility that we are talking about in medical tourism, they cannot be registered anywhere in the civilized nation of these 7 nations. They cannot practice for one single day with their existing criteria of credentialing.
So here in the Cayman Islands, our government, as part of the deal to allow Health City to come and build their facility and to operate here, essentially brokered a deal whereby physicians who ordinarily, under no circumstances, would be able to work anywhere else in the world outside of India, basically, in terms of the, like you said, the big 7 countries, we have essentially allowed them to come here with their unique qualifications and operate as physicians and as specialists performing surgeries and all sorts of other things, yeah?
Correct. Now, I am a case in point towards this effect. Yeah, I am an Indian. I have Indian qualifications. I graduated medicine from India. I became a surgeon in India. I got a master's in surgery. But when I wanted more experience, I went to United Kingdom. And I was very politely told, we don't accept your qualifications, even the medical degree. So first I had to sit their equivalency exam called the PLAB. And then I was put on the General Medical Council's register as a medical doctor, not as a specialist, because my specialist qualities were not acceptable in the United Kingdom. So he told me I have to train with them, and then after the training, appear in their exams, and if I pass, then I became a specialist, which I did. And it was only then when I came back here, these credentials from UK allowed me to be put on the principal list of the Cayman Islands. But here we have a situation where we've given a backdoor to say, nope, you don't need that anymore.
Right. So traditionally, you know, there are quite a few Indian physicians here who were on the primary list.
Right.
They would have gone through, if they were not, you know, in the UK at the time, they would have gone through a similar process as
Yes,
you've just
in
pointed
one
out.
of these 7 nations,
Yes.
they were accepted as put on the principal list in those countries. So that was acceptable here.
Right. Okay. So that, I mean, as a layperson, that sounds a little concerning to me. Is that something that should be of concern to patients? I mean,
No, absolutely. I mean, in the sense that I don't understand for one single day why a Caymanian should accept standards anything less than what an average UK citizen is experiencing. And we have enjoyed this up till now, up till medical tourism came about and this backdoor entry system came about. I mean, please understand, in the first 2-3 years, this wasn't a problem. They were doing medical tourism and tertiary care because cases were referred to them. But then suddenly a regulation snuck into the thing which allowed them to also offer services locally. Then it became a concern. Okay, how can you have a person who was supposed to be flying under the banner of medical tourism now also doing local practice, but still flying under the banner of medical tourism, and his qualifications are now okay?
Right.
It isn't okay.
and this secondary, you know, backdoor, as you've coined it, is called institutional registration.
Correct, yes.
So I just want to make sure that our viewers again are understanding some of the terminology that's being used. So institutional registration is basically the type of registration that Health City as a facility has. They're an institutionally registered facility.
Right.
And that's important to understand, because when we start talking in a minute here about some of the proposed legislative changes that are coming down the pipeline, they are geared specifically to institutional registration.
Correct. And by that virtue, we mean it to be Health City because there is no other institutional place which employs institutionally registered physicians other than Health City.
Right.
Okay? And
Okay.
over the years, since 2013, a number of regulations have come in to help them in their practice, but mostly in their local practice. Okay? Not for their medical tourism or not for their tertiary care. So one by one, these regulations have come in, and this particular validation bill which is coming forth is supposed to ratify all of these changes and will make this law almost written in stone, which cannot be challenged in any form or manner.
Right. So, just to play devil's advocate, we have spoken to someone kind of off the record connected to Health City, and they have essentially said that, listen, the only reason why they have now moved out of what people see as the traditional box of medical tourism is that when they were treating people for, say, for example, heart and lung issues that were being referred to them, they have to now offer all of these additional services in order to support that. What would you say about that? And in fact, the position is that they attempted to work with the local HSA to say, how can we partner with these additional services that our clients need?
Well, okay, I mean, that is a pretty feeble attempt. Anybody who runs a hospital know that ancillary services are required and will be essential, will be needed. So if your business plan did not even consider that fact, then I really question the intelligence of the people who are running this show from day one. And to say now, because we are here, you should allow us to do this, is kind of a little feeble cry to please help me in this situation. But at the same time, don't look at rules, don't look at regulations, have pity on us, can't let us allow us to do it. It doesn't work like that. They always have the option to employ physicians who are on the principal list. Okay, and we do see that occasionally they have employed physicians who are on the principal list.
Is there any reason, in your opinion, why they wouldn't do that? Like, what's the difference? Is it a financial reason? Do you pay those people more if they're on the principal list, if they're principally qualified, in other words?
I would obviously think so, yes. If you have somebody who's qualified enough to be on the principal list, he would be gathering or demanding or actually benefiting from a salary which is very pursued with his qualifications. Otherwise, he wouldn't be leaving the place where he's working to come over and work over here. So that would be the first reason that we would think, yes, there is a financial incentive here as to why they will not recruit and employ physicians who can be on the principal list.
Interesting. Okay, so let's move forward a little bit now and look at present day. Some weeks ago here at Cayman Islands, we started getting a number of messages from, it was numerous physicians saying that they understood that there were some legislative changes coming down the pipeline specific to institutional registration that was very, very concerning. And we've reached out to a number of physicians to sort of get some, feedback on this. We also reached out to Dr. Lee, who is the Chief Medical Officer. Obviously, he's employed by the Cayman Islands government and works for the ministry, essentially.
Correct.
And he has, given us a response, which we'll discuss here in a minute. But this proposed bill has a number of changes, and we'll talk about one that is no longer an issue, which I think is a bit of good news. So let's start with the good news part of it. One of the proposed changes, and you can again explain this in detail, was to actually have Dr. Lee's position sit on the Medical and Dental Council. In what capacity? It's just a board?
He would have been a voting member of the council, and this just doesn't fly in the scheme of things in democracy, because Dr. Lee's role is a planning and an advisory role for the Ministry of Health. And in a separation of powers of principle, you keep the planning away from the regulatory, whereas the MDC or the Medical and Dental Council is a regulatory body. They enforce the law.
Right.
So you cannot have a body which is planning and advising principles also sitting in on the enforcement side of things, first of all. And Dr. Lee himself will also admit that his job is to promote and push through plans for the government. So how can he sit in on the council, whereas the council is supposed to be completely bereft and devoid of any influence, internal or external? And that is the reason why a statutory body is formed. Otherwise, the ministry could have just formed its own body and dealt with everything that was there. But no, there is a reason why the council is separate.
Right.
And this defied that logic. So this was a great objection to us, and I'm sure Dr. Lee will understand and respect us when we say, hey, you're not supposed to be sitting on that. You're not supposed to be casting a vote on a legislation that you are supposed to push through.
Okay. So it is our understanding that just as of yesterday, the Legislative Assembly is back in session, and this concern must have been, on the floor of the Legislative Assembly, but now the government is withdrawing.
We hear so. And
that's what we've heard,
that.
yes, that the government is withdrawing this particular component of the amendment, whereby the Dr. Lee, the Chief Medical Officer, again, working for the Ministry of Health, would also be sitting on the Medical and Dental Council, which every single physician that we have spoken to here at Cayman Road has essentially said that is a significant conflict of interest, as you've just explained the reasons why. So hopefully we will be able to confirm in short order if that has indeed been withdrawn. And so that was one of the concerns that you had initially about this legislation. I'm sure that your letter, which was penned to the government, has the Office of the Premier or the Ministry of Health responded to your letter by any chance?
I've had a very kind response from the Governor's office. We're thankful for that. And he in turn reached out to the Attorney General and to the Ministry of Health, but I have not had any response from Mr. Alden or from the Ministry of Health, as was promised to the Governor.
Okay, so the Governor indicated that you'd be hearing from them, but you've not heard from them. And we, unfortunately, that seems to be a bit of a modus operandi for this current administration, that they just don't respond to official correspondence very well. So Section 12 of the HSA law, which was repealed in 2017. Now, we want to break this down a little bit because a lot of our viewers will remember this because it caused a lot of backlash against the government of the day, especially in social media, whereby a young lady, a family basically, have a special needs child who the reason why that child is in the medical condition that they're in is because of negligence on the part of the HSA. That whole case was litigated. The family lost the case, but there was a scathing commentary, I think even by the judge, and after that the public picked up on it, that it should not be a situation where the HSA as a statutory body has complete immunity and cannot be sued, because that's essentially what it was.
Right.
The HSA law, section 12 of that, did not permit anyone to sue the HSA. So they could kill you, they could do anything, and you weren't able to sue them. They were immune from lawsuit.
Unless you prove bad faith. And
Right,
bad faith
and bad
is
faith is
impossible
difficult.
to do.
Yes, that's near the bar for proving, and the little I know about laws, people will know, that's a very high bar. So as a result of public pressure, the government decided to repeal Section 12 of the HSA law, and now people can sue the HSA for negligence. Now, this is significant because in the proposed amendment now of the current health law, it seems like there's been almost a word-for-word copying over of that same Section 12 of the HSA law, which was done away with in 2017, into the current health practice law. Is that your reading of this as well?
That was my initial reading and still remains so. But now we are given to understand that there is a plea that we have misunderstood this highly technical piece of jargonry. All right, I don't understand it. Most people don't understand it, but they are now saying it. Oh no, it only applies to a certain section of the law which deals only with the period of registration of institutionally registered physicians.
Okay. So let's break down what your interpretation is of the new amendment that's being proposed. And again, the irony of it is when we reached out to Dr. Lee, he also said that people were misinterpreting the law. So what is your interpretation of what it says at the moment?
Well, if what Dr. Lee says is true, then this is an extremely poorly worded law, open to interpretation or interpretations, and should be absolutely taken back and reworded so that average Joe Schmo can understand it.
But what's your interpretation? So let's start with
If what they're saying is purported to be true, that it is only applicable to a certain section pertaining to period of registration, I question it. Why does this period of registration need to be amended by a law? And I cannot think of a single reason, single circumstance in which a possible lawsuit could ensure, from which this piece of legislation is supposed to provide them immunity from any legal action.
Right. So the proposed change is actually worded in such a way where it would give institutional, and it's specific to institutional registration, it would give them complete immunity from legal action, and it seems to be retroactive, and then it goes back in time. So on the first reading of it, that's interpretation that everyone that I have spoken to has read. And what does that mean to the average person?
I cannot fathom why the language is there, immunity from any legal action, when it pertains only to the period of registration.
Right. So if you go, what it means is if you go to the HSA on the average reading and something happens to you, you're unable to sue them for negligence and so on, right? So Dr. Lee, we did reach out to him here at Cayman Mall Road. He has said, nope, everyone is misunderstanding this. And my position as someone who, like I said, is a little bit familiar with the law, is if you're writing legislation that everyone, including people in the profession, technical physicians are not understanding themselves, you've got a problem.
Absolutely,
and maybe you need to go back to the drawing board. The drafters of that legislation have failed in whatever your attempt was. So his explanation, let's break that down now. His explanation says what?
This only pertains to the period of registration, and all other lawsuits are applicable. And for financial damage, anybody who needs compensation, it is possible. But then I question, why is this word there if it only pertains to the period of registration? Can you give me an example where you can envisage that a lawsuit will ensue?
Right.
And nobody
And when
can
you
give an
say
answer.
the period of registration, what does
Yes,
that mean?
I mean, what happens with institutional registration is the law stated that they will get an initial period of registration for 2 years, followed by 2 more periods of renewal of registration, but the word only was there, that this was limited to a period of 6 years of continuous working.
Right.
There was a reason for that. The reason for that was medical tourism institutions were an unspoken factor in the Cayman Islands. We wanted to see what they were going to do, how they could be checked, how the balances were put in place. So simply as a measure of that factor, a limit was put on the registration. Hey, we wish to revisit this situation and see. But as I have mentioned before, no checks, no balances were ever put into place either for the memorandum of understanding or for the way this institution functioned in our fair islands. Until date, there is no legislation or anything which allows us to go and say, hey, what are your results? What are you doing?
Right.
Nothing like that.
And initially, HSA's, not HSA, sorry, the Health City position was they were happy to bring in physicians and roll them out
Absolutely.
sort of this
Yeah.
6-year period of time.
Right.
Now, my understanding is there's been a change of heart, and of course, it's beneficial for them from their own business plan, again, which has changed, for them to keep physicians on for longer periods of time for ongoing patient care continuity concerns. So one of the changes as well in this proposed legislation is to actually change that 6-year period of registration.
Right.
So now they would be like any other primary
Correct.
physician, where they are only subjected to basically work permit
Correct. Yeah.
regulations. So they would have an indefinite period of registration
Right, yeah.
for
But
institutional.
here is where the difference lies. Here there is an attempt to bring them at the same level and at par with the principal list, give them the same benefits. But the reason why they are on the institutional list is because their qualifications were not acceptable. So why don't we bring them up to par as far as the qualifications are concerned? Where
Right.
the Cayman citizen is concerned, who is entitled to and demands the services which an average person in the United Kingdom can have. No, why is this change taking place? So, okay, let's bring it all up to the same par. And that is my plea here. We should have one system of regulations which deals with the delivery of healthcare, not this fractured system.
And so Dr. Lee, by his own admission, is now saying that this fractured system, which, as you said, was part of the initial agreement with Health City under the Bush administration, has allowed for this argument to emerge that these legislative changes are necessary in order to bridge the gap between institutional registration and primary registration. And you're saying, why are we bridging the gap in that manner by changing the legislation to accommodate the institutional registrations instead of just saying become qualified through the same
Correct,
means
yeah.
as everyone else in this country?
They just need to employ physicians who can be on the principal list. The answer is
Yeah.
as simple as that.
Right.
I mean, they are a foreign business entity. They have come. We have afforded them great benefits based on our good faith. And now we find that they are not willing to abide by our laws. They want to change our laws to suit them. I don't think we should be able to do that. We should protect our own citizens and give them the same standard of healthcare that we are used to having, and we should have. And as far as these laws being changed, we do read very, very simply in the laws themselves that the cabinet has the authority to make any law, change any regulations, but at the same time it says it has to be in public interest. It has to be in national interest. It has to be considering public safety. Can anybody here tell me that lowering of educational qualifications is in the interest of public safety? Heck no, it isn't. All right? And if such a decision is going to be made by a cabinet, I strongly suggest that they involve the public in this discussion as to what kind of physicians should be dealing out healthcare in this island. All right? It is a public issue. It is a national issue. Involve the public. Have a public consultation as to what kind of healthcare qualifications are necessary for the physicians delivering healthcare. We already have the health practice law, which is pretty straightforward and strict. Why don't we just adhere to it? Why do we have another system which is allowing this to happen, that to happen? It is going to lead to complications down the line, and it's
Right.
already happening.
Okay, now what would you suggest people who are watching this video? We're going to obviously put this through to our social media platforms as well as our website. People would be watching this and they're probably shocked to hear that, you know, this is even happening. What do you recommend that they do? Should they contact their representative? Should they contact the premier to get some further explanation on this, on why this is happening?
Yes, on both counts. I do believe people should reach out to their respective MLAs and tell them as to what kind of healthcare they expect to have. And if I put it very simply, should I not expect the same kind of healthcare that mother country has? And is there anything wrong in following the principle that mother country has, which we follow in our health practice law as per the principal list of registering physicians on this island? And people should reach out. People should demand to say, you know, why haven't you discussed this with us? That you are lowering the standards of healthcare.
Right. Okay. All right. Well, Dr. Mohanty, thank you so much for joining us today on Cayman Mall Road to break down this very technical situation that's occurring with some proposed changes to the health practice law. And again, for those of you who are listening to this and you'd like some additional information, as with all bills, the bill is publicly available, so you can certainly get a copy electronically online. You can message us here at Cayman Mall Road and we'll show you a copy of the bill. Lawyers, doctors, the common person on the street needs to read this bill with a view to understanding what it says. And if it's confusing, you know, professionally trained individuals, it may confuse you as well. But try to read it with a view to asking the right questions of your elected officials. And again, there are a number of persons in the medical profession in particular who are very alarmed and concerned at the proposed changes. And we can already see that that alarm has transferred in allegedly one aspect of the bill, which was going to see the chief medical officer also sitting as a member of the medical and dental clinic. That aspect has allegedly already been withdrawn. So that certainly, I think if that is true, which we will be seeking to confirm, that certainly leads one to question how much thought really went into the drafting and presentation of this bill. It has to be debated in the Legislative Assembly, so we all have to ensure that not only as laypersons that we understand what's going on, that our elected officials are also very cognizant and aware of what is happening in lieu of these proposed changes as well. So again, folks, thank you so much for tuning in. Dr. Mohanty took time out of his busy schedule to speak with us today. If you have any additional concerns, do reach out to us and we will, as indicated, provide you with a copy of the bill. Again, Sandra Hill here reporting with Cayman Mall Road.
Thank you.